Well, good evening, everyone. I'd like to welcome you to this special meeting of the Cunningham Town Board. It's Monday, March 27th, 2023. Will the clerk please call the roll?
Ms. Wu,
Here.
Mr. Evans,
Here.
Ms. Hersey,
Here.
Ms. Colasetti,
Here.
Ms. Bishop, Ms. Wilkin,
Here.
Mr. Quisenberry,
Here.
Mayor Marlin,
Here.
Ms. Chenoweth,
Present.
Next item on the agenda is public input. If anyone wishes to address the Cunningham Town Board, please step up to the microphone and state your name for the record. None. We'll move on to resolution number T 2023-03-23R, which is a resolution authorizing certain individuals to sign checks for Cunningham Township.
This is a housekeeping item to essentially remove the former assessor, Wayne Williams, from the bank account and to add Ivana Owana. So we'd like to be able to move forward so that we can do due diligence with the finances.
Any questions for Danielle? Grace?
Thanks. Just had a quick one. Is that the only change here from the previous one is just switching Wayne for Ivana?
Correct.
Okay, thank you.
Okay. Is there a motion?
I'll move approval of resolution number T-2023-03-023R, a resolution authorizing certain individuals to sign checks for Cunningham Township.
Second.
Moved by Chandra, seconded by Mary Alice. Discussion? Will the clerk please call the roll?
Ms. Wu,
Yes.
Mr. Evans,
Yes.
Ms. Hersey,
Yes.
Ms. Colasetti,
Yes.
Ms. Bishop,
Yes.
Ms. Wilkin,
Yes.
Quisenberry.
Yes.
That motion passes. Next item is resolution number T 2023-03-024R, which is a resolution authorizing the supervisor to sign a memorandum of agreement with the Housing Authority of Champaign County and the Urbana School District for the sponsor-based voucher program for family service providers.
So this is a long-awaited announcement. It was voted on by the Housing Authority on Thursday, and I noticed in that resolution that it could start on the 23rd. Right now, we have families without access to vouchers, so I wanted to bring this to you before the next meeting because it means we can speed up voucher provision for families by 2 weeks. So essentially, what the Housing Authority has done is to put in their Move to Work program sponsor-based vouchers, and they prioritized and had an RFP for organizations to submit to be the referring agencies for vouchers. They asked organizations working with families, and these are specifically vouchers for people with children, for households with children. So essentially, what this will do is, given that COVID vouchers for homeless individuals are limited and running out, this will allow us to continue to move families into project-based housing vouchers or use vouchers to house them at subsidized rates. So we are partnering with the Housing Authority and USD 116 for this. So far, we've helped 50 households apply and supported, so we've helped 50 households with children apply. We've actually helped over 130 households apply. And so we're building on this partnership and our partnership in the school district, identifying families that are housing insecure and homeless to help them apply for vouchers and access those vouchers. So this is kind of a dream come true, and with your affirmation, we can move forward and start recommending people who are working with families who are working with for vouchers.
Any questions for Danielle? Is there a motion?
I'll move resolution number T 2023-03024R, resolution authorizing the supervisor to sign a memorandum of agreement with the Housing Authority of Champaign County, the Urbana School District 116, for a sponsor-based voucher program for family service providers.
I'll second.
Moved by Mary Alice, seconded by James. Further discussion? Will the clerk please call the roll?
Ms. Wu,
Yes.
Mr. Evans,
Yes.
Ms. Hersey,
Yes.
Ms. Colasetti,
Yes.
Ms. Bishop,
Yes.
Ms. Wilkin,
Yes.
Mr. Quisenberry.
Yes.
That motion passes. Last action item is the Cunningham Township Annual Town Meeting Agenda for April 11th, 2023.
So we're required to have an annual meeting. You will see the agenda is basically what it has been in the past. From now on, I want to have a property disposition item. So we had that last year. We ended up not using it. So we're surveying our property to see if anything needs to be disposed of or given away. And if we do, then we'll present those at the annual meeting.
Any questions on this? Yes, Chris?
Danielle, is this the meeting where citizens can propose a referendum of any kind?
Yes, but there's a deadline to propose that referendum, and I defer to the clerk's office. But I'm not sure if that deadline is passed.
Yes, it has.
Okay, thank you.
Questions? Do we need a vote on this? No?
Oh, wait, no.
Voice vote will do this.
Okay, all those in favor of the annual meeting to be Tuesday, April 11th, 2023, please say aye.
Aye.
All those opposed? Okay. We'll be at 6 o'clock, April 11th. Reports of officers.
Yeah, so I put this item on the agenda partly just to, so I'd be able to give an update. I wanted to invite Esther Pat of the tenant union to step forward to the, and she and I will be presenting, and I expect Ruth Wyman, who is the attorney for the tenant union, to join us momentarily. So, last week, City of Urbana Human Rights and Equity Officer Carla Boyd and City Attorney David Wesner, representing their own position as well as that of their supervisors, Mayor Diane Marlin and Chief Administrative Officer Carol Mitten, gave a presentation to the Urbana City Council claiming that the Human Rights Ordinance, which has banned housing discrimination based on source of income, is largely unenforceable, and that landlord participation in the Housing Choice Voucher Program is voluntary. The slide I will quote from is, it's the city's position that we do not currently have the legal authority to compel a landlord to participate in the voluntary, underlined Section 8, or TBRA voucher programs. This is false. It is false. Not only were many of their statements factually inaccurate, stating this poorly researched and ill-considered position publicly is extremely damaging to the public interest. It undermines the work of Township and every service provider working with low-income residents in the county. It messages false information to the business community, signaling them that it is open season for discrimination in Urbana. I want you to remember that the people who are hurt most by rejecting vouchers are those who rely on them the most: children, people with disabilities, and seniors. I am speaking tonight to correct the public record. If this had been a private conversation, I would have been able to give this information before. But I am part of a fair housing coalition. It includes representatives from the city, the township, along with the continuum of service providers, Regional Plan Commission, the Housing Authority of Champaign County, and the tenant union, as well as state organizations Hope Fair Housing and Housing Action Illinois. We have been coordinating for over a year on how to address housing discrimination. Many of us worked with State Representative Carol Ammons and the late Senator Scott Bennett, who were co-sponsors and champions of the Fair Housing Bill that now prohibits source of income discrimination across the state. This group has had active discussion and a recent coalition email thread to prepare for our fair housing workshops next week. There's been no mention on this thread of the city's position, this public presentation that happened last Monday, nor any questions to the lawyers or the experts on this thread. Carla Boyd stated last week, between Attorney Wesner and myself, we have talked to many people. Even though many of these people believe that state law compels the landlords to participate in this voluntary program, none were willing to provide a legal opinion to support this view. No representatives from Cunningham Township or the tenant union, who together have spearheaded the Fair Housing Coalition, have ever been asked to provide a legal opinion. So such a declaration was at best premature and at worst harmful to the public interest. I'm going to lay it out for you very clearly, and I will send this to you in email. Fiction. Vouchers are not a source of income. This is fiction. Fact. Vouchers as a source of income have been legally established in the city of Urbana since 1979, with a clarification by council when this was contested in 1996. In the Human Rights Ordinance, Chapter 12, Section 1237, and I quote, and I would encourage you to read the Human Rights Ordinance, because many of the things that were stated are in direct opposition to the language of your own ordinance. It is the intent of the city of Urbana in adopting this article to secure an end in the city to discrimination, including but not limited to discrimination by reason of race, color, creed, class, national origin, religion, sex, age, marital status, physical and mental disability, personal appearance, sexual preference, family responsibilities, matriculation, political affiliation, prior arrest or conviction record, or source of income, or any other discrimination based on categorizing or classifying a person rather than evaluating a person's unique qualifications relevant to an opportunity in housing, employment, credit, or access to public accommodation. I further read Section 1239, the definition of source of income. The point or form of the origin of legal gains of income accruing to a person in a stated period of time from an occupation, profession, or activity, from any contract, agreement, or settlement, from federal, state, or local payments, including Section 8 or any other rent subsidy or rental assistance program, from court-ordered payments or payments received as gifts, bequests, annuities, or life insurance policies. That's your state, that's your city code. The state of Illinois, Resolution 2007-75, the source of income definition in this borrows directly from the definition in the ordinance for the city of Urbana. It is exactly the same. They have been enforcing their human rights ordinance protection for voucher holders for decades. Source of income means the lawful manner by which an individual supports himself or herself and his or her dependents. If there's any question as to whether or not this is a source of income, we simply need to look at the 2004 appellate court case, Godinez versus Sullivan Lackey. The court found that Section 8 vouchers are lawful means of support under the above definition. The court ruled against the landlord that they were discriminating against the applicant by denying her tenancy based on her source of income. This is literally 9 years ago. Second, fiction. Participation in the voucher program is voluntary. I listened to the text of your meeting last week, this morning, and this word was used over a dozen times. The fact is that since 1979, it has been illegal in the city of Urbana to discriminate based on source of income. In last week's presentation, it was stated that HUD considers the Housing Choice Voucher Program a voluntary program. This is true outside of the state of Illinois or any jurisdiction where a source of income discrimination is not prohibited. This argument is like saying that an employer in Urbana or Champaign can deny me a job because I'm a lesbian, because on the federal level, there is no protection against employment discrimination for LGBTQ residents. We are in Urbana and we are in the state of Illinois. It is not an optional program in these two jurisdictions. Third, fiction. An application is required to enforce a source of income protection. Let me just consult common sense for a moment, and then I will read your ordinance. We don't rent to blacks. Is that not an actionable statement? Can you state something? Can you put it in writing to the township, which they have done, and I've sent it to the mayor and the human rights ordinance officer in writing, saying that we do not either take people with felony convictions, or we do not accept source of income. It was stated that you have to submit an application, and that it's very difficult to enforce without that. But reading from Section 1264, Housing and Commercial Space, from our own Human Rights Ordinance makes it very clear there are 3 points. It is lawful unpracticed, it shall be an unlawful practice to do any of the following acts for a reason wholly or partially based on discrimination. We have now defined discrimination. We know source of income is a kind of discrimination. We're now going to points 1, 5, and 11. It is illegal to refuse to negotiate for, enter into, or perform any sale, exchange, or lease of any real property, or to require different terms for such transaction, or to represent falsely that an interest in real property is not available for inspection purpose, purchase, sale, exchange, lease, or occupancy when it is in fact so available. It is illegal to make, print, or publish, to cause or be made, printed, or published any notice, statement, or advertisement with respect to a transaction or proposed transaction in real property or financing related thereto, which notice, statement, or advertisement indicates or attempts to indicate any preference or limitation. Under that statement, dozens of landlords are discriminating because they already have put on their applications, and I have sent this to you. We have created a report about it, talking about children are not allowed, non-students, we only rent to students, we don't rent to people with criminal convictions, we don't take housing vouchers, we don't participate in a housing choice voucher program. And the third, Section 11, to refuse to negotiate for, enter into, or perform any sale, exchange, or lease of any real property because of discrimination against any party to the transaction, any member of the family of any such party, any person using or occupying or intending to use or occupy the real property, or any person using or occupying any real property in the area in which such real property is located. We have an excellent ordinance. It's been on the books for a long time. It has been crafted over many, many decades. The fact of the matter is that the city of Urbana is and has been reluctant and sometimes outright refused to enforce fair housing law in the city of Urbana. And they are now saying they're not able to enforce fair housing law and that it is a voluntary program, which is not true under local or state law. In addition, it is harmful for the city of Urbana to state that it is a voluntary program in public, for it to be on the public record that city staff state this. It emboldens landlords who otherwise would wish to follow the law to discriminate against participants based on source of income. It makes my job and the job of every single person in my office 10, 20 times harder for this misinformation to be distributed to the public. The law is a community pact. It affects not only what is allowed, but also the culture. Most landlords we know want to comply with the law. And when the city, a public entity, signals that they no longer need to comply to it, the consequences can be devastating. And they will not be devastating to most of the people sitting around this board. They'll be devastating to people that you very rarely see or talk to or hear from. But they are the people that we work with every single day at the township. And they consistently tell us how difficult it is and how they are turned away time and again based on source of income. And when I am asked to take a case to the city, I do at times. Many times these are homeless residents, and they are residents who are simply trying to find a place. They do not have time to go through a lengthy, months-long process of standing up for their rights. Instead, they are trying to look for a home, and I can't argue against that. And so what I want is I want this council to get an independent legal opinion. I want you to hold staff accountable for misinformation. 4 council direct staff, in addition to the mayor. The mayor is not the only chief at the table. So 4 people need to speak up. And I need you to come to meetings and speak to fair housing. Next week, I will send you the information. I believe Esther has also sent it to you. You can come to one of 3 meetings and you will be able to speak to legal experts on this case and get a different opinion. And with that, I would like to pass it over to Esther Pattis, the director of the tenant union, served on city council for a number of years and has direct experience with many of the pieces of history behind this. Thank you, Esther.
Turn on the mic too, and turn on the mic and
I'm sorry, okay.
pull it forward.
Thank you. Yeah. It's my habit to support the mask wearing wherever people are, so I don't want to offend anyone. I want to explain to you a little bit of just about renting that I think gets, a lot of people don't even understand basics about how the process works of people renting an apartment and how that matches with Section 8. And I'm going to be quick about it. If a landlord's listing an apartment and I'm shopping, I'm going to call and ask to see it. There are some landlords who will not show the exact unit. Some apartment complexes won't. They want to show you a model. As long as they won't show anyone the exact unit, that's totally legal. In fact, I said this to Danielle earlier, and clients are always shocked when I say it's the tenant union, but a landlord can do anything they want as long as it's not prohibited by law. And one thing that's prohibited by law is discrimination, so a landlord can have any process they want for how they lease as long as they apply it to everyone equally. And if a landlord doesn't want to show an exact unit and wants you to sign a lease, if they can get someone to sign without seeing it, that's what happens. Most landlords will show a unit to a prospective tenant because most tenants won't sign without seeing it. If I went to view an apartment, and we use the word view, I would conduct an inspection that is more comprehensive than the housing quality standards inspection conducted by the city, by the housing authority. And I'm not going to presume, but I would bet anything that Mayor Marlin would do the same because she has owned rental property before. She knows what to look for. And I think most of you are now old enough that even though you're homeowners, if you were renting, you would check to make sure every single window has a lock on it and a screen, and you would open every window and make sure it stands open by itself and that it shuts and it fits properly in its frame. I'm not saying inspectors don't do that, but they check for the windows. I mean, and I don't want to make it sound like it's a light inspection, but this concept that opponents of fair housing put forward that there is this onerous burden on a landlord to submit to an inspection. I'll describe a simple process. I call, I want to see the apartment, I go see it. A couple days later, I call and say, I think I want it, I'm going to come back. I can come back with my mom, or with my best friend Margie, or with a housing quality inspector. And the inspection is looking at things, looking at, is there evidence of leakage in the ceiling or at the baseboards? If you observe roaches, you write it down. Is there a smoke detector? If there's any gas, is there a carbon monoxide detector? Et cetera, et cetera. And when the inspector is done, if they find violations, they give a notice to the landlord that these violations have to be corrected before housing authority will accept this unit for rental. And if the landlord says, I don't want to do the repairs, it's over. And that's not unlawful discrimination. And they never send the report over to the city to get the city to cite the violations. So a prospective tenant and somebody hired by the housing authority are both aware of code violations in a rental property, and they walk away from it, and life goes on. What is a real burden to people with vouchers, and this is why there has been a nationwide movement and more than 50 states, cities, or counties have adopted laws like Urbana's and like the new state law, is because the way the market works excludes a lot of people with vouchers without discriminating. And the simplest thing, I'll go back to my example, I see an apartment advertised, I call, can I see it? I go see it, I think about it, I call them the very next day and say, I think I'm interested, sorry, it's already rented. And anytime, anybody, if I'm looking for a place and you're looking and you have a voucher and I don't, I am getting that place before you. For that matter, if I am willing to see it sign for it after one viewing and you want to come back with your mom or your best friend, I'm going to get it, you won't, because I'll get it first. And almost all landlords do rent on a first-come, first-served basis. There might be a misconception that if I have a voucher and I saw the place on Friday and I told the landlord I'm interested, that now the landlord has to stop showing the place to anyone because they're waiting on me. That is not true. Nothing requires the landlord to wait on anyone, unless the landlord's policy is the day someone says, I want it, they won't show it to anyone else, and then they put you first on the list. I personally don't know landlords who do that. Another biggie that really hurts people with Section 8, or here it's housing choice voucher, but hurts people with vouchers or tenant-based rent assistance, and you can confirm this yourself by just get online and shop for apartments yourself. Gobs and gobs of apartment listings. Go to landlords' websites, go to Craigslist, Zillow. And if you look at when they're available, almost anything available, and most anything advertised, not almost everything, a huge amount of it is available in August. And so when I'm looking for stuff, when we're looking for stuff for people with vouchers, we're looking for available now. And you can go to their website for, Westgate Apartments in Champaign or Ramshaw Real Estate or University Group, and they'll have, 50 apartments listed, and 47 will be available in August. And so we look for the available now. People with vouchers are only going to be able to get things that are available now. Whenever they are looking, is it on the market now? And there's also a complication from the Housing Authority that they will only inspect an unoccupied unit. The overwhelming majority of apartments in Champaign-Urbana rent months before a tenant moves in. So the total volume of apartments or houses that are left available to people with vouchers before we get to discrimination is a small percentage of the total market. And then it's very frustrating. This is the easiest way to prove discrimination. And I'm talking whether it's kids or disability or anything. If they tell you the place isn't available and 3 weeks later they're still showing it, that's how people catch this. That's how you catch race discrimination too, any discrimination. Mr. Evans asked me before the meeting, well, how do you prove discrimination? It's really hard. But as far as Section 8, or housing choice voucher, there are landlords who could completely refrain from discriminating and never rent to anyone with a voucher because they lease way far in advance. But when something is on the market and the landlord says, I won't take a voucher, the landlord is holding a unit vacant rather than renting it to someone because of that person's a demographic characteristic. And as Ms. Chenoweth pointed out, if a landlord said, I won't rent to you because you're black or because you have kids, and they're just gonna hold the apartment, and then a month later they can find a white person without kids, that's discrimination. And it's just astounding to me that a brand new state law was passed in January, and already the city of Urbana has pronounced the law is unenforceable. Like, do you think the entire Illinois legislature, and who are filled with lawyers, and the Department of Human Rights, and the Chicago Human Relations Commission, and the dozen organizations statewide who are working this, they're all wrong, and the city of Urbana staff is right? I mean, seriously, that just isn't the case. And I came here tonight mainly in support of Ms. Chenoweth's point that what you did last week was just deplorable. I wish you had just privately decided you're not going to enforce the law. That's happened at least a dozen times since the law first passed around here, depending on the case or the respondent or who was working in city legal or whatever. But for you to announce, not just that you're not going to enforce the law, but you just gave credibility to every single landlord in town who wants to discriminate, to say blow off to everyone who works at the Township, Regional Planning Commission, Family Service, the homeless shelters, Champaign-Urbana 10 Union, the entire community of service providers in this town counts not on winning cases in court or winning hearings before the Human Relations Commission. We count on enforcing laws the way most laws are enforced. One, the majority of people comply because it's the law, and they will continue to comply unless you tell them they don't have to. And two, people who don't necessarily voluntarily comply back down quickly when they face a consequence. It is true, no law could ever force anyone to take a voucher, just like no law can force you to feed a parking meter, no law can force you to drive the speed limit. But if you break the law and you get caught, there's a penalty. And there is a penalty for landlords. Any property owner who has been offering any housing to the public, you can discriminate your little heart out if you keep it private, but if you put a sign in the yard or post anything on the internet or you hand write an index card and push it, use a push pin to put it up on the bulletin board in the laundromat, like in the old days, that is public offering it to the public. And as soon as you offer it to the public, you cannot discriminate at all in any way that is not based on the relevant qualifications for the opportunity in housing. And I want you to know, with every law it works this way. The Urbana Landlord-Tenant Ordinance passed in January of 1994, and It didn't go into, it was affected leases signed after that date, so it really didn't even go effect till the fall. I worked on campus at the time at the tenant union, and thousands of students came through that office shopping for apartments, and I was already hearing about how landlords in Urbana say we can't show it till the next day because they have to give 24 hours notice. And landlords were voluntarily, and the chambers were filled with landlords who were against it, but once the damn thing passed, they went ahead and complied. And when a landlord doesn't comply, I don't know if there have even been 5 people in 29 years who have sued a landlord under the Urbana Landlord-Tenant Ordinance. And there are several provisions in there where violation of the ordinance results in the tenant being entitled to double the amount of their monthly rent plus court costs and attorney's fees. But hardly anyone ever goes to court. All you have to do, there are still landlords to this day who violate tenants' privacy, but most tenants write a letter to the landlord saying, the law says I can sue you for 2 months' rent plus court costs and attorney's fees. Please don't do this again. And voila, landlords don't do it. I've worked at tenant union I don't do client service anymore since the COVID shutdown, but before that for 40 years. And I can't tell you how many landlords have given back damage deposit money, stopped violating their tenants' privacy, corrected building code property maintenance violations without ever even having an inspector walk in the door. When you present people with this is the law and this is the penalty, a whole lot comply. And that is what you stole from the children, senior citizens, and people with disabilities of Urbana last week when you announced that nobody should believe anyone who tells them that they can't refuse someone just on the basis of a voucher because City of Urbana says the law is invalid. And we are going to now, Ms. Chenoweth and I and the people we work with are going to have to do a great deal to put out the public word that the law is good and what you said was wrong. It would be really nice if Urbana would rethink this. And I know as long as I've been here, the majority of city council members have supported this ordinance. But there has always been pushback from the administration, and I would hope that the council and the administration, Mayor Marlin, would get together and walk back the extreme incorrect information you announced last week so that those of us who are working to help low-income people get housing don't have one more barrier to climb, that being resistance from the city. Thank you very much.
Thank you, Esther. And if I could ask Ruth Wyman, as the supervisor's guest to the town board meeting, Ms. Wyman is the attorney for the tenant union, and I've requested, there was a statement that was said that there had been no legal opinion made on this, so I reached out to the attorney for the tenant union, and it sounds like there's an opinion that has been requested. Ms. Wyman.
My name is Ruth Wyman.
Could you make sure your microphone's on, please?
Thank you. My name is Ruth Wyman. I am the attorney for the Champaign-Urbana Tenant Union. I have my practice about a block away and have a general practice here in Champaign County as well. I've worked with the tenant union for about nearly 30 years, but now serve as legal counsel for the Champaign-Urbana Tenant Union. I'd be happy to work with legal counsel for the city of Urbana in making sure that it is clear and that counsel for the city, who I know work on many issues, not just issues about housing, but certainly many issues, to make sure that they understand the laws and are clear in being able to direct staff and any landlords with regard to the mandatory nature of the Human Rights Act, the Landlord-Tenant Ordinance as well. I previously served on the City Council in which we voted on and clarified issues with regard to the Landlord-Tenant Ordinance, the Human Rights Ordinance as well. And I intend to work to prepare a legal memorandum and want to make sure that it's clear to council members, to board members, and to staff and the mayor. I'm happy to help in preparing and gathering any information on issues with regard to the Human Rights Ordinance, with regard to enforcement, causes of action as well, to make sure that all of the residents of the city of Urbana, regardless of their source of income, have their legal rights protected. My office number is 217-239-1544. My office is located inside the downtown Urbana post office building, so do not hesitate to reach out to me if you have any questions, if you desire any other information, but I'll be working to prepare documentation and a memorandum for legal staff as well, just so that they have that background and information as well.
Thank you, Ruth.
Just for the record, I would like to state the city has no intention of dismantling our human rights ordinance or enforcing what's in place now. We were seeking clarification on the state law. We in fact received additional clarification today. And we'll be providing information to the council, but thank you. We'll be happy to work with you as well.
I appreciate. I look forward to continuing to work with the City of Urbana. It's even better than Bora Bora. So, thank you.
Wish we were in Bora Bora. But yes, thank you for the information. And we also will be attending the meetings next week that you're referring to. And I apologize for any anxiety last week's call. That was not intended to provoke anxiety or to increase uncertainty. Obviously it did, but we stand firm on opposing discrimination in the city of Urbana, but we were simply trying to get clarification on the state law. Grace.
Thanks. Thank you very much to the supervisor and our guest speakers for some more information on this. I really appreciate it. Wasn't here last week, but watching the presentation, I was definitely wondering some input from people who spoke tonight. So thank you for sharing with us. And I'm definitely in support of looking into this more, and I'll look forward to hearing what the state said and some other recommendations that we get to be sure that we can enforce this in a meaningful way. Thank you.
We've got a case in the works now, as a matter of fact. So, Jan.
Yeah, thank you for this information and taking the time. I think it's really important, and I think it's also important for our community members to hear. If you have questions, if you're seeing complaints, please continue to reach out for support. We need to get this clarified, and I look forward to seeing additional information. I appreciate the information that Esther Pat's already sent to us, and from Ms. Wyman, we'll look forward to seeing that legal standing too. I think it is important for us to recognize the harm, right? Like a misunderstanding, not having clear answers from federal and state entities, it can be frustrating. And I hear that, but I think it's also important to think about the impact, right? So many people are already struggling just to find housing, and anything that can result in it becoming more difficult is something that I think we need to own, right? Those of us who were here last week for not pushing back more, for not asking for more time and additional input. And I would like to see additional legal input on this, because I think it's really important for us to have that firm standing. And this is not a new ordinance. It's new for the state. It's not new for Urbana. And so making sure that we are able to provide the necessary legal standing so that when people are facing this discrimination that we've taken a very clear stance against for years, that people know that the city will continue to support them. That's one of the amazing things about Urbana. We're supposed to be leaders, right? Like the state is just catching up, and we shouldn't be making it more difficult for people to exercise the rights that they have. So thank you all for bringing this to our attention. And I would encourage us to continue this conversation in council as well, because not everyone who watches the township watches the council, and vice versa.
And you bring up a good point. It's not a new ordinance, but this town is never the same place twice. It's kind of like TJ Maxx. We have a lot of new landlords. A lot of properties have turned over lately. We also are a very transient community with constant new residents. So this is an opportunity, once we get this clarified and can very clearly, it's time to re-educate people. It's time to re-educate the entire community, and it's an opportunity to do so. James.
All right, yeah, thank you. Thank you for the comment, and thank you, Esther, for the emails and the additional information. I do think it's important that as we have this conversation that Lily Walton be here, because the Housing Authority is an important part of this conversation. She was able to answer some questions for me at the meeting on Monday, and now I wonder whether I heard her answers correctly, because she talked about the triangle of relationships created by these programs, and I heard very clearly that one of the parts of the triangle is the relationship between the housing authority and the landlord, which I heard was a voluntary contract that they enter into. And so I have to understand why that's not voluntary, right? I need to understand that better, because I need to understand why we believe state or local ordinance can compel when it comes to federal programs. That's the rub, and I'll need someone with legal authority to explain that to me. Sure, you can.
Sure, come on up. We have till 7 o'clock.
This live?
Yes.
Okay. HUD, the Department of Housing and Urban Development, as you know, is a granting agency. It gives you your home funds and and CDBG and all that. It also has a civil rights division that enforces civil rights laws. There is no federal civil rights law protecting against housing discrimination based on source of income, or sexual orientation, or marital status, or several other things that are covered by state and local law. So, from HUD's point of view, and they'll say it a million times, and that's what Lily Walton was saying too, Section 8 is a voluntary program. But in more than 50 states, cities, and counties, local fair housing law prohibits discrimination, prohibits refusal to accept a housing choice voucher or Section 8 voucher. And so it is a voluntary program in the eyes of the federal government, and until January 1st of this year, it was a voluntary program in the eyes of the state government. And before 1979, it was a voluntary program in the eyes of the city of Urbana. And it goes back to a landlord can do anything they want except what a law prohibits. And so HUD considers Section 8 voluntary, and probably always will until the federal government changes their laws. But any jurisdiction, state, county, or city, that prohibits refusal to accept a voucher, I guess technically, as I said before, it doesn't make the program not voluntary, but if you don't participate, you're in violation of the law. And I don't know if that doesn't jive with you, but that's basically, it's not a federal violation, but it is a local violation, and now it's a state violation. And so in that sense, the program's not voluntary. Yes, Danielle?
Well,
you want to add to that?
I
Or you
wanted to
ask me again?
follow up.
Okay, go ahead.
So do we have support from the state on this, from the
From the
Attorney
state of
General?
we have
or-
support in two ways. Well, actually, the Attorney General will probably issue an opinion. In fact, last Monday I was thinking, am I important enough to be able to get the Attorney General to come here himself? And we might just do that, maybe even the governor, I don't know. But there are two ways the state of Illinois has told you that you have to, that there's landlords, that it's not voluntary in Illinois. One was in Illinois, that's not voluntary. One was the appellate court decision in Godinez in 2004, where in the city of Chicago and in Cook County, and they didn't mention it, but also in Urbana, where local laws prohibit discrimination based on source of income, including vouchers, it's not voluntary. That was, if you read the decision, that was the decision in Godinez. It's not voluntary. It had a sentence at the very end of the summary of the decision saying that the court did not rule on the question of whether it would be a choice to not participate if participation caused an onerous financial burden to the landlord. But in the facts of the case they were hearing, there was no evidence of that. And I would speculate that since there is no cost, the rent is the landlord gets the exact same amount of rent, and the contract that they have to sign with the housing authority, the HAP, Housing Assistance Program contract, is it's either 1 or 2 pages, and it is a recitation of what's in the lease. The purpose of the housing authority requiring the landlord to have a contract with them is the landlord is promising the housing authority that it's not lying about what the terms of the contract with the tenant are, because there were landlords who would set the rent for the fair market rent required by HUD, like the apartment will be $850 a month, but then they have a separate contract with the tenant for the rent to be $1,020 a month. And the HAP contract is a contract promising what's already in the contract, but there's not a single thing that HUD requires the landlord to do in the HAP contract that the landlord is not required to do in the landlord's own contract. For example, it says whether or not the landlord's lease says it'll say which utilities are paid by the landlord. HUD doesn't dictate that. Housing Authority doesn't dictate that. They just copy whatever it says in the lease. And that's its sole purpose. And that's really why I cannot stress enough how the claim that a landlord has to do anything other than sign the contract agreeing to the contract that they agreed to the tenant is a false claim, because there is nothing else required of the landlords other than submitting to the inspection, which they submit to when they show apartments. And actually, pardon me for taking more time, but there was some mention about, I was so angry, frankly, but something about the lease provisions. I think it was actually your question about prohibited lease clauses, or maybe it was yours. It was one of the two ends. There are numerous lease clauses that are prohibited in various places. In the city of Urbana, chapter 12.5, subsection 10, has a list of lease clauses that are prohibited in the city of Urbana. And I believe that list is more extensive than the Housing Authority's list. The example someone gave here, it was probably Mr. Evans, because I heard a male voice, it was one end, or it was Mary Else. It's the clause that says, a lease clause that says the tenant waives their rights under the law is unenforceable under Urbana landlord-tenant law. And there are also some state laws that impose certain mandates on landlords. Like if you are renting property that was built before 1978, the law requires you, even though it could be conceded, landlords will argue this is interference with private contracts, but Illinois state law prohibits you from renting to a tenant in a building that's built before 78 or older without giving them the lead paint disclosure information. That's specific information that has to be given to them. There's a state statute, 765 ILCS 735, that says no lease can require a tenant to pay for any utilities, or no landlord can rent to a tenant any place where the meter for the individually metered utilities to the apartment includes service to any area outside the apartment. And there's a penalty of treble damages, okay? So that's prohibiting what landlords can do. That's what laws do. And landlords push back against any laws because they believe, the organization believes as a matter of principle that government should not regulate rental housing. And that's really what you guys are up against. And the Section 8 thing is just one arm of the whole belief that government should not tell an owner of a private piece of property what they can do. And actually, the laws say they can. And I don't know, Ms. Walton even brought up the business about damages. Anytime anyone's talking to you you're talking about vouchers, and all of a sudden people start talking about tenants doing damage, that's bigotry. That's what it's all, that's the proof, that's the tell, that it has nothing to do with business, and it all has to do with prejudice. They don't want to rent to, quote, those kind of people, end quote. And a lot of them will come right out and say so. In fact, when the city of Champaign was considering this matter in 2006, the property manager of Royce and Brinkmeyer Properties did a PowerPoint presentation for the council, arguing that statistically, Section 8 people aren't as good tenants as the general population, and that is why the law should not require people to take them. And I would just beg all of you, one last thing, since I've got the mic. Thank you so much for letting me have all this time. Anytime anyone says anything about Section 8, rewrite the sentence and replace it with disability, race, or children, or sex, and see if it still makes sense to you. Which is Danielle's point, when you were told that if someone just flat out refuses to even take your application, that's not actionable. Yes, if they said, I won't rent you because you have kids, or I won't rent you because you're black, that's actionable. If they deny it later and you have no proof they said it, that's lots of luck winning. But it is wrong to refuse to even consider someone just because of a demographic characteristic.
Thank you.
Thank you. Chandra.
So we heard that discrimination is difficult to prove. What's your advice or suggestion on how someone applying for housing can prove that they're being discriminated against?
I don't know how easy it is to prove, but here are the important things to do. Step one, and I've been giving this advice as long as I've worked at tenant union, do not reveal anything about yourself that might be the grounds for discrimination, which is why it's so hard for people with race discrimination. But even on the phone, if they can't tell what you are, find out. You call, is the apartment available? Yes. Ask, what floor is it on? because that gives you the opportunity for them to, that they might tell you, oh, we've got apartments on the second and third floor, so you know it's more than one unit. That won't always work, so they'll just tell you a floor. Then you go and you look at the place, and if you're interested, you ask for an application and see if you can, see if they'll let you apply. And you don't tell them I have a voucher. You don't tell them I have children. You don't tell them I have a disability that you can't see. You just go ahead and apply and see what happens. And then if they don't accept your application, but you believe you were otherwise qualified, then you file a discrimination complaint with a place where you count on them not throwing it in the trash or burying it or delaying it for a year, which you can't always find somewhere. Well, we suggest if it's race discrimination, file with the federal, state, and local. If it's anything covered by federal law, file with HUD, the state, and locally. For years, HUD and the state have been together where you can only do one, but you try for all. If it's something only covered by Urbana ordinance, like source of income up until this year, you file with Urbana. And notwithstanding any problems here, if it turns out that City of Urbana is not a bad referral, then I would advise people to contact the City of Urbana Human Rights Officer and the state agency. When that happens, and that's if you get an application denied. And when that happens, then it is best to, and of course, and the whole way along, you should keep all the information and document things, write down which apartment number you saw, so you have as much information as possible. The first step when it comes to human rights, or if they go to the township, or if they come to our office, is we'll call the landlord and say, oh, you might not realize the law doesn't allow you to just say no Section 8, and if the person's qualified, you need to take them. Would you please take them and see if they will? And, it depends on the case. We've had cases, I'll tell you, one thing I've heard a lot from clients is when a landlord expresses reservation about renting to someone, usually this is kids or disability, because they'll come right and say it. Well, this really isn't, well, we like to rent to wheelchair people only on the first floor, even though the building has an elevator. We had one of those. Often, the first thing the person should do is say, isn't that, you can say it real laid back, isn't that against the law? Whoosh, it's amazing how many landlords have backed down. Over the years, the stories I've heard, especially with kids. Oh, I'm not saying I won't rent to the children, which is exactly what they just said. I just thought you might not like it for your children. And if that doesn't work, just saying, isn't that against the law? Then, again, you go through the complaint process and see if the landlord will back down when confronted with that's against the law. And I cannot give anyone any guarantee, but I want to say one more thing. Probably should wait till, I don't know who watches these programs anyway, but everyone you know and everyone who's a service provider, it's total bull. It's ridiculous and bogus to say, I can't file a discrimination complaint because I'm looking for housing. You don't have to choose one or the other, and service providers need to know this. If someone's been shopping apartments, they found a place with XYZ Realty, and XYZ said, we don't take vouchers. File the complaint that XYZ said they wouldn't take vouchers, and keep shopping. And sometimes XYZ will back down in response to the complaint before you find another place anyway, and then you get it. So the short answer to your question, Ms. Bishop, is it's really hard to prove discrimination, except the fact that many people who discriminate are stupid and make it obvious or admit to it, and that's the good thing. But when this law first passed, when it was first being considered, and council member asked, but how are you going to prove it? It's so hard to prove. I stand before you as a 67-year-old who's worked my whole life on this stuff. A large number of people will comply with a law just because it's a law, or when caught not complying, say, oops, I didn't mean it, and back down. And that is the main way the law works. And this obsession that people have about, well, unless we're certain we can win in circuit court, throw the case out, you shouldn't. You should push through as far as you can go, including if you lose in court, because then at least you fought for something that mattered.
One more question, Sharice.
You might as well stand right back up, Ladybug.
I don't know you, but I knew your mom on this issue and others, and yeah, what would you like to know?
Because it's weird. Past week, I have had to talk to 2 different people about issues regarding their housing. Not talking to one, emailing another. This does not. What you're talking about is not just regarding vouchers. This is tenant stuff. And one lady, I think I even gave her your mobile number. But I was looking, I was like, this is the person you need to talk to, because for sure I'm not the authority.
Sure, that's good.
But I do understand what you're talking about, because I rented when I lived in California, and Yeah, I was not surprised with how sometimes the manager handled that kind of stuff, and I also had to tell him that's against the law, you know, when I would run across him interviewing somebody. But the other thing is that I think it's important for the public to understand that although we're doing a lot of talking about vouchers and so on and so forth, that this is about apartment hunting, period.
Yes.
And I think it's just important for them to know, not just apartment hunting, but even house hunting, if you're renting a residence or whatever. And the most important thing, too, is that if you are renting from somebody, that you're renting a house, you need to make sure that they are registered with the city of Urbana, as we've come across quite a few people who aren't, I know in the past couple of years that were renting property and they weren't registered. And that is also an issue. And so I really would like for people to have that information. If if they call you or the tenants union, that may be another piece of information that has to be added to that particular thing, that if you are renting a house from or an apartment in the city of Urbana, that person, that owner, is supposed to be registered with the city of Urbana.
Yeah, Ms. Hersey, I think it'd be absolutely wonderful if the city of Urbana would notify, every time someone new buys a rental property, would notify, when you become aware of it, would notify them of the rental registration ordinance and the landlord, the whole chapter 12.5 of city code, which is the landlord tenant ordinance, the registration, rental registration, and chapter 12 of city code, which is human rights. And also, if you have kids, it's not smart to call a landlord and say, I'm looking for a place for me and my kids. Just say, I'm looking for a place. Keep the kids a secret as long as you can, because that does appear to be the single most common form of housing discrimination out there. But like I said, a lot of people solve it for themselves by just saying, isn't that against the law? But yeah.
In the 2 minutes we have, can I provide 3 quick answers to the questions? So the first is the housing authority nor the township can compel landlords to participate. I think the use of voluntary by Lily is somewhat inaccurate, but the city is the only one that can compel them to participate. So the housing authority's relationship is with HUD that does not compel this, right? And the township does not have that authority. I've looked into it because I would like to have that authority, but I don't. Secondly, how do you prove it? Chandra, as our office has been asking for years of the city, you test. It's what the late Eric Jacobson used to do when he lived in Ohio, is he was a white tester to test for racial discrimination. It's been done before, and the level of discrimination in Urbana is such that we need to test, and I've been requesting that. It was one of the recommendations I presented to the Human Rights Commission, to the mayor, and to the council in 2018. The third is that to support Ms. Hersey, to support rental registration, we require that landlords are registered to receive rental assistance. We don't have to, but that's our support for the rental registration program. And by doing that, we ensure that people are registered. And if they do not register, then we report it to the city and we continue the rental assistance so that the tenant is not penalized because of the landlord's actions. But we do make sure and we check against that. There is a coalition meeting tomorrow, and if you're interested in speaking directly with Hope Fair Housing, let me know and I will send you the link. That's all.
Thank you. With no further business before the town meeting, this meeting is adjourned and we'll start up immediately with the council meeting. Thank you all.